के लोग भारत में ज़्यादा नहीं सर, हिंदी में ज़्यादा। ये कौन सी न्यूज़ है सर? ये लोकतंत्र टीवी है। लोकतंत्र जी, अडानी जी भी कभी प्रोवाइड किया। लाइट ज़्यादा। नमस्कार, मैं हूँ देव। इस वक्त आप देख रहे हैं लोकतंत्र टीवी। इस वक्त हमारे साथ हसीन साहब आप आज बहुत बड़ा कॉन्फ्रेंस कर रहे थे 4 लेबर कोड को लेकर, लेकिन कई सारी विरोध भी हुई है लेबर कोड्स को लेकर। दिल्ली में कई जगह प्रदर्शन भी किए गए। क्या है, कैसे इसको एडजस्टमेंट करें, कैसे इसे समझौता करें?
कोई भी नया कानून आता है तो उसके लिए दोनों पक्ष बोलते हैं। कुछ लोग जो हैं जो उसके साथ सहमति रखते हैं और कुछ लोग जो हैं उसको अपोज करते हैं। और ये जो 4 कोड आए हैं, ये पुराना जो लॉ हमारा चल रहा था लेबर लॉज के बारे में, उसकी कंटिन्यूटी में है। शुरुआत वहाँ से हुई थी, पर अब उसको एक जगह पे लाने के लिए, जैसे हमारे क्रिमिनल लॉज के साथ हुआ था, उसके भी कोड अलग बन के हुए। तो अलग अलग लॉज में बड़ा लोगों में ये था कि भी क्या है, हमारी एंटाइटलमेंट क्या है, प्रोविडेंट फंड की, ग्रेच्युटी की, वेजेस का है, उसका क्या डेफिनेशन क्या है उसका। हम वर्कर हैं या हम सुपरवाइज़र हैं, हमको क्या मिलेगा। तो ये सब जो है अब एक जगह पे 4 कोड में आ गया है। एक कोड जो है वो वेजेस को डील करता है कि क्या क्या एंटाइटलमेंट होनी चाहिए। सर एक ही डेफिनेशन है वेज की। पहले के लॉज में अलग अलग मिनिमम वेजेस का अलग डेफिनेशन था,
अब एक साथ है। लेकिन जो लेफ्ट थिंक टैंक है, जो लेफ्ट विचार को जो मानते हैं, वो तो बड़ा आपत्ति जताते हैं। सदन में भी आपने देखा कि एक हेल्दी डिबेट होने के बजाय बड़ा लोग एक दूसरे पे प्रत्यारोप लगा रहे थे कि ये जो है उद्योगपतियों को सीधा फ़ायदा पहुंचाने के चक्कर में।
नहीं, उद्योगपतियों को अगर फ़ायदा मिलता है तो इसका मतलब नहीं कि उनको फ़ायदा देने के लिए ये कानून बनाए गए हैं। ये कानून हमारी जो ईज़ ऑफ डूइंग बिजनेस है उसके लिए ये कानून बने हैं। तो उसके अंदर अगर कोई चीज़ें जो है वो एम्प्लॉयर को उसको सूट करती हैं तो वो ठीक है, पर इसमें लेबर का भी जो है पूरा उसका भी जो सेफ गार्ड किया गया है कि स्ट्रॉन्ग ट्रेड यूनियन बननी चाहिए। जब तक स्ट्रॉन्ग ट्रेड यूनियन नहीं होएंगी तो बार्गेनिंग पावर नहीं बन सकती है।
वसीम साहब, आसान भाषा में कैसे लोगों को कन्विंस करेंगे कि ये फ़ायदे की चीज़ है? जैसे कि आप कह रहे हैं कि जो एक पहले जो बिक्री चीज़ें होती थी कई लेबर कॉर्ड्स, अब वो एक प्लेटफॉर्म पर सिमट कर आ गया, जिससे कि लोगों को आसानी होगी।
बिल्कुल
आप यही कह रहे हैं?
बिल्कुल आसानी होगी इसमें, और वर्कर्स के भी हित में है। कई चीज़ें जो हैं वो सोचते हैं कि उनके हित में नहीं है, तो उनके ऊपर भी अभी रूल्स बनेंगे। अभी स्टेट के भी व्यूज़ आएंगे 45 डेज में। तो इश्यूज तो हमेशा किसी भी नई कानून में हमेशा अराइज होते रहे।
लेकिन लोगों को आप कैसे बताएंगे? इसके लिए क्या है, कोई जनरल अवेयरनेस चीज़ें आप लोग लाएंगे? क्या एडवर्टीजमेंट, जैसे कि ये आप ही के लिए है, आप ही के हित के लिए है, जो सब
यही इसीलिए तो ये कॉन्फ्रेंस हमारा पूरे दिन का हुआ है, जिसमें अलग अलग व्यूज़ आए हैं अलग अलग लोगों के। अब जैसे मिस्टर कुलीन गुंदालवेज सुबह बोला, उन्होंने कुछ प्रोविजन को बोला कि ये ठीक नहीं है, तो अब उसके ऊपर जो है लोग अपने अपने विचार उन्होंने पेश किए हैं। और अब हम इसके ऊपर एक पेपर बना के फिर वो पार्लियामेंट में भेजेंगे, वो गवर्नमेंट को भेजेंगे, उसके ऊपर लोग विचार करेंगे।
Gentlemen, I think now everyone knows about WebNI, or hopefully you will know after this. I think you're all experts here on labor law. So I'm going to talk a little bit about technology, specifically legal technology, and the opportunity we have now to use these codes. We've heard the additional secretary in the morning talk about how technology plays a big role as far as these 4 codes are concerned. And 2 other points he picked about. One was around cooperative federalism, which I'll also pick, as I mentioned, technology. And the other was, the journey from Vidhi to Vikas to Viksit Bharat. where of course, we've heard that labor law is, one of the most important legislation as far as ease of doing business and economic prosperity is concerned. But technology also has a massive role to play in it. So I'm going to make a use case and just talk about some ideas in terms of how technology can be used for compliance under these 4 codes, from very basic to very advanced compliances, but also from very simple to very complex, and how you could potentially think about using technology to make some complex compliances slightly easier. So I think if you look at the 4 codes more generally, right, in some way they are rewiring the employer and employee relationship. And a lot of compliance is also now moving digital. We've heard this panel and the panels before as well talk about technology and AI. But we're also seeing that, India is now moving towards a digital first regulatory state as well. So the question under these 4 codes is not really if you comply, it is also now becoming, can you prove that you have complied? And the proof is increasingly moving towards a digital proof and evidence trail as well. And some people also spoke about the difficulty in, FNFs in 2 days. I would say technology is probably the only answer or only solution to that, especially in massive organizations employing hundreds and thousands of people. So what we really need is a slightly more newer playbook, slightly more advanced tools and simple HRMS tools as well. So we'll talk about a few points. The first one is, of course, the definition of wages. We've got a unified definition of wages now across the 4 codes. And that caps a lot of, in terms of allowances, whether it's PF, whether it's gratuity or others as well. But there is a big risk. If you miscalculate what the wage is, that potential risk could, increase over years. It could be sort of dormant for multiple years and it could create a problem. So that is definitely one reason why there should be a slightly more legal or tech playbook as far as compliance is concerned. The other one is the Industrial Relations Code and the GR Committee. Various panelists spoke about the GR Committee. I think grievance redressal is not new to India, right? It's been there across sectors, across laws as well, whether it's banking, whether it's consumer, and now it's being made mandatory across the 4 codes as well. I would say this should be looked at, it may be fairly new, but I would say it should be looked at as an opportunity to really resolve disputes and resolve grievances and really nip them at the bud before they escalate to any external forum. Of course, there are compliances around timelines, equal representation of employees, proportionality, and I think that is also a technology first grievance redressal setup internally as well. I think would be very helpful, not only from a compliance perspective, but also when the inspector comes knocking or you're looking to submit anything in court, you could pretty much have an audit trail, auditable, defensible record, which can be, printed in one go and submitted to court as well. And inbuilt into the GRC can be some sort of a private mediation mechanism as well, which is sort of built in right at the top in the employment agreements, but also built into the GRC in a way that if your grievance is not resolved in the committee, you can also use external experts, mediators, to try and resolve the disputes, whether it's trade union disputes, whether it's one-off worker disputes, or whether one-off employee disputes as well. And this will also be in line with the Mediation Act, which hopefully should be notified sometime soon. I think another compliance that a lot of people mentioned about was, the inspector now becoming a facilitator as well. And the inspector can also demand proof digitally as well. Now, we'll have to wait and see, whether a simple Excel sheet of payroll and, PDF payslips would suffice as far as digital proof is concerned. Or they may go ahead and really, ask for proof of process as well. In which case, a simple Excel sheet and PDF payslips may not really be ideal, may not really make sense. So I think process-wise, I think that is critical that, you're maintaining all your evidence in terms of how compliances are being done. So it's not merely a checklist, but something that you can use to make the entire process more efficient as well. And I'm going to borrow the concept of 5 Ps, which is very common in HR. And I'm going to replace 1 P. So the 5 Ps is, performance, people, process, policy, and purpose. I think all of those are very relevant as far as the codes are concerned. But I'm going to replace the purpose P, just because I don't want to make it 6 Ps, to say proof. If you study the codes in its entirety, these 5 Ps are extremely critical, not only for HR, but also for compliance under the codes. So if you use technology, the fifth P, if you replace purpose with proof, I think that is what the codes are all about. That, you need digital proof, whether it's before your inspector, whether it's before the courts tomorrow, or whether it's just more generally for compliance and to avoid penalties. So, and policies would sort of fit in, with discussing about changing or amending of policies to bring in line with the four codes as well. And I know some panelists spoke about legal oversight with HR systems as well. So I think that is quite critical. You may have an HRMS, for instance, which does payroll calculations, which deducts TDS, PF, calculates leaves. But I think that an integrated system which has legal oversight and which can give you 20 other things as far as compliance, I think that's the way forward from a compliance perspective. Another concept that I want to mention is that there is a term called inspection in a box, essentially, which can also be adopted to the new labor codes. So, and I've broken down it sort of in 3 points what that really means. One is, digital registers. We don't have formats. There is a possibility that each state may have their own format in terms of what the register is. So I think organizations could potentially look at digital registers in specific formats for each state. You could also, which could auto-flag potential breaches as well. So if there is any breach, for instance, it can be auto-flagged in the system as well. And then slightly more legalistic is AI first responses to notices as well. So if you're getting notices, for instance, I think we're all using, GPT and other LLMs in some form or the other, but really creating a specialized process where you can have first drafts of notices, for instance, whether it's a show cause notice or anything else, where you've already put in the codes and regulations and everything. I think that will make lives much easier for in-house organizations, but of course, for law firms as well. And the last 2 concepts that I want to touch about, slightly more advanced. One is around pre-litigation check. I think what could also potentially be interesting, and I'm sure there'll be solutions, whether organizations build it in-house or external solutions that come up, is can there be some sort of pre-litigation check before you want to do something? Say I want to terminate an employee or 100 employees or X number of employees. Or say suddenly I think of a new incentive that I want to give someone or a new bonus. Can I put that into the system and see what that means legally? Do I have to comply with these 5 steps before I can announce that? Do I need to do X, Y, Z things? What are the implications that I have from a compliance perspective? Does it put me at risk? If it does, what is the element of that risk? Is it 10%, 20%, 80%? We've got different scoring elements across laws, but I think something of analytics and from compliance perspective, I think is also critical for organizations to start thinking about. And then the last one is actually quite interesting in section 42 of the Industrial Disputes Code around arbitration. If you look at how the clause has been drafted, firstly it says the Arbitration Act is not applicable. And secondly, it says that you have to agree to arbitration after the dispute has arisen. So you cannot really have arbitration clause in your agreements and then move to arbitration. Once your dispute comes about, after that there has to be a written agreement on arbitration, then both parties potentially appoint an arbitrator, and then they've brought the concept of an umpire as the third or presiding arbitrator that we usually see in arbitration. But I think that is of course untested waters as far as labor law is concerned in India. But I think we're moving in the right direction, and I would argue that organizations and law firms who advise organizations should potentially look at this as an opportunity for companies to build a forward-ready organization from